Okay, so welcome everybody. Thank you so much for being here. We are recording this event, so in case you don't want to be, in case you don't want your personal data to be collected, please have your camera and your microphone off. Next time we will organize differently. Welcome also to our panelists. I will introduce everyone now. So the Brussels Privacy Hub is honored to host this high-level event on the Artificial Intelligence Act, in which we will comment on the European Union Council position of 29 November on the European Union Commission proposal of last April for an Artificial Intelligence Act. And we will foresee the steps forward together. We decided to have today institutional and academic speakers that could complement each other and react to the Council and Commission texts. That is why we have 2 members of European Parliament, also scholars, and the EDPS in the panel. We organized this panel just 1 week ago, and we received 280 registrations in 7 days. This reveals how huge is the interest and in the topics and in the proposal in general. We announce you that this meeting is being recorded. The video will be available there. I first introduce myself, and then I will introduce the stellar panel. So I am Gianclaudio Malgieri, one of the 2 co-directors of the Brussels Privacy Hub, together with Professor Christopher Kuhner, and I'm Associate Professor of Law and Technology in Lille and Guest Professor in Brussels University and other European universities. So I'm going to rapidly introduce our amazing panel. I think we just missed 1 panelist, and then we have a whole. So I will start from the present ones. So I will start from Ms. Kim van Sparrentak. She's a Dutch member of the European Parliament for the GroenLinks political party. Since 2019, she's part of the Greens and European Free Alliance group at the European Parliament, member of the Parliament Committee on the Internal Market and Consumer Protection and the Special Committee on AI in the Digital Age. And she's shadow rapporteur for the Greens on the AI Act. Now I see, hello, Kim. Now I see that also Mr. Benifei is joined. Great. I was just introducing the people. So Brando Benifei is the head of the Italian delegation of the group of the Progressive Alliance and Socialists and Democrats in the European Parliament. He's member of the European Parliament since 2014, and he serves on the team in the Committee of the Internal Markets and Consumer Protection, and in the Special Committee on Artificial Intelligence in the Digital Age, where he serves as the Parliament's co-rapporteur on the Artificial Intelligence Act. Then we have also the honor to have here other 2 great panelists, Dr. Wojciech Wiewiórowski, European Data Protection Supervisor since 2019. He was Assistant Supervisor since 2014, with a long career of legal scholarship, and also he's also Doctor in Constitutional Law and Public Service in Polish DPA. And then we are honored to have also Professor Mireille Hildebrandt, Professor on Interfacing Law and Technology at Vrije Universiteit Brussel, Co-Director of the research group Law, Science, Technology and Society, Chair of Smart Environments, Data Protection and the Rule of Law in Radboud University, and she also leads the ERC Advanced Grant for Research on Counting as a Human Being in Computational Law.
You muted yourself.
Someone muted me. So before giving the floor to our set of speakers, for the benefit of all present, the Brussels Privacy Hub would like to briefly introduce the European Union Council version of the AI Act, so their compromise text. After this introduction, we'll have 45 minutes, maybe a bit less, for panel discussion, and then a final 15-20 minutes for Q&A. So I'll give the floor to Vincenzo Tiani. He's our Program and Dissemination Coordinator at the Brussels Privacy Hub. He's Brussels partner at Panetta Law Firm, doctoral researcher at BUB. He teaches digital rights and he writes on many newspapers. So I'm trying to close my sharing so that he can share his slides. Vincenzo, the floor is yours.
Let me know if you can see my screen. Can you see my screen?
Yes.
Yes,
okay.
We can.
Okay, thank you, Gianclaudio, for the kind introduction. So, since we have so many great panelists, we are already running out of time, so I will be as short as possible. So, as you know, the AI Act was introduced this year in April by the European Commission, and the idea is to propose an high-risk approach. Last week, the Council, under the Slovenian presidency, published its compromise text with some interesting news. So, social scoring in the AI Act is seen as a high-level risk. So, the top of this pyramid. That means that it should be banned. So the Regional Commission proposal, in fact, prohibited social scoring, but only when used by public bodies. If you have ever watched the episode of social scoring of the famous series Black Mirror, you know what we are talking about. If you haven't, it's basically the evaluation or classification of the trustworthiness of individuals based on their social behavior, characteristics. The introduction, so the news of introduced by the Council is to extend this ban to also to private actors, and also considering social scoring not just based on trustworthiness, but also of any kind of individual evaluation and classification. I would like to remind that Giovanni Buttarelli in his manifesto called for a ban of social scoring. So it is a very, it's an issue it's very important to address in the best way possible. So concerning harm, the Commission's proposal prohibited AI practices that could either produce physical or psychological harm because of subliminal mental manipulation or exploitation of individual vulnerabilities based on age and disability. The Council's proposal excludes the AI user's intention and just focuses on the mere effect of distorting behaviors. So it's not just about the intention; it's really the effect. And this manipulation could be based not just only on age and disability vulnerabilities, but also on social and economic conditions. So we think that it's a good improvement of the text. Going to another important issue, the biometric recognition, real time. We know if you've read the text, it's treated in Article 5. So normally it's banned, but actually there are several exceptions, especially when we are talking about law enforcement use in public spaces. So now the Council introduced several amendments. So the attribute remote has been removed. That means that the scope will be extended. On the other side, they added threat to critical infrastructure and health. But on the other side, the threat has not to be imminent anymore. So the imminent characteristics has been removed by Article 5. Concerning authorization in urgent cases, let's say in the regional text of the Commission, law enforcement authorities, if they couldn't have the time to ask for a previous authorization to judicial authority, they could have done after. The Council proposes that it can be done after, and the latest can be during the use of the biometric recognition tools. And of course, if the judicial authority refuses the authorization, the law enforcement authorities must immediately desist from continuing the operations. National security is considered an exclusively domain of the member states. So if AI is used exclusively in the domain of national security, should not fall within the scope. As a Brussels Privacy Hub, Major Claudio, we commented that, of course, this choice could have undesirable effects because, of course, if there are no guarantees, there are no safeguards, the safeguards provided by the AI Act, this could lead to increasing the margin of error in the implementation phase. So they changed a bit some definitions: biometric identification, and not also categorization, like it was provided in the European Commission text. AI system, quote, intended to be used for the real-time and post-remote biometric identification of natural persons without their agreement. What does it mean? So the novelties are that the Council has deleted, as I said, the term remote, but also categorization, leaving only the purpose of identification. What does it mean? It means that AI system that can categorize suspects, criminals, will be considered high risk only if they also identify individuals, not just for categorization purposes. Agreement, so the Council used the term agreement, but of course we think that this choice could lead to validate as no high risk all those cases in which even a concluding behavior of the subject could be considered valid. Of course, we know that GDPR is clear about consent, action. It could be express, informed, and so on. That's for this reason we think that it would be better, also for a greater consistency with the GDPR, to replace the term agreement with consent. Concerning data analysis, according to the Council, law enforcement authorities could use and analyze large amounts of data coming from different sources. In this case, won't be anymore considered as high risk. Again, this means that won't be all the safeguards guaranteed by the AI Act won't be in place, and this could, of course, have a negative effect on fundamental rights. There's an exception for research. There are many academics in this panel, so it could be seen as a good thing. It's a broad exception for all the uses that are made for all the outputs used for the sole purpose of research and development. We think that, again, this could lead to serious effects to fundamental rights. An alternative could be, promote the use of sandboxes in which the rules could be suspended for research reasons. There are still, and I'm going to stop in a minute, some other unresolved issues. So the Council asked for more practical guidance, especially for, of course, small medium enterprises. We think that emotion recognition biometric categorization is still not considered high risk use, and also there is a lack of individual rights and remedies in the proposal. The Council also, concerning small medium enterprises, think that asking for a error-free and complete training, validation, and testing of datasets could be a requirement too stringent. So they also ask for perhaps lowering the fines for small medium enterprises. Otherwise, they think that only large companies, so big tech and others, could afford the cost of compliance.
I think we have to run to the speakers. I think you finished your slide.
That was the last point. So just rethink about the chain of responsibility, because all the companies and all the technologies are really interconnected and the boundaries are very blurred. That's it. Thank you very much.
Thank you very much, Vincenzo. It was a very, very effective summary. I take this chance also to thank other people I didn't thank before. So our Managing Director, Mohamed Demircan. For people who are curious of more details, Vincenzo already referred to our report on the website of Brussels Privacy Hub. Now it's time for comments. I know that some panelists need to leave a bit earlier, so I will give the floor first to them. I will ask to reply briefly to the first question. So we have another couple of rounds of questions, but I'm very optimistic, I know. So let's start from Mr. Brando Benifei. He's the AI rapporteur, so the co-rapporteur of the AI Act. So the council was quite, the council position was quite something for the parliament, I think, also for discussion. So do you think the council proposal is an advancement or a step back compared to the initial commission proposal? Do you foresee that the parliament will easily find compromise on this text on the points that Vincenzo was making, or on other points maybe?
Well, for sure, you can hear me well, right? Okay, so for sure the parliament will appreciate some points that were mentioned. I'm sure that there will be a large support on the extension of the social scoring prohibition in the sense that was underlined. I'm not sure that we are completely satisfied on the issue of biometric surveillance and biometric data, also the issue of the lack of even categorization as a high risk of the emotional uses in a larger sense. I mean, there are, I would say, lights and darks, plus and minus. But it's not easy also to say now, because we only agreed a few days ago how the parliament will deal with it more precisely. So we need to see how the colleagues and the various political groups will approach, because I give you one example that makes why these dynamics are still in a kind of finalization. There was the jury rapporteur, that was Axel Voss, a colleague that is well known for his work on these topics. Now he has withdrawn from that. He will not be anymore the jury rapporteur, so someone else will be, and the jury committee will have not so many, but some specific competences, and it will be involved also in the trilogues because of the agreement that we reached, even though IMCO and LIBE will have the lead. So we are still in this phase. In my opinion, it will take time, also because I'm convinced that the council will still have to discuss and might even reopen some of the points that they have reached agreement on. So I think that in some months we can say more precisely how is the situation on the, I mean, how much it will be difficult to reach out on a compromise.
Thank you very much. I take this chance just to remind that this is not the official and final position of the council. It was just a first step, because we are receiving also some feedback about that real time. So just to clarify this, but for us, it's still a relevant first step that we should comment, because now it's the moment, right? And Brando Benifei mentioned the different political parties. And here we have the fortune to have another representative of the European Parliament, a shadow rapporteur on the Act. So I would like to address Kim van Sparrentak to ask her, what are the problematic points that you still see in the council proposal, the open issues on the table, and if you're optimistic about the discussion or not? Thank you.
Thank you very much. Well, let me start with saying that I think it's very good to see that the council has kicked off their work already on this important file before we managed to do so. And I'm really happy to see that they want to strengthen the social scoring prohibition to private parties. I think Europe is at a really important crossroads now in our approach to technology, and we know, especially on this file, that the world is watching, because this is the first trial to actually have AI legislation, and this is really our chance to choose for strong rules that put people above the interest of large businesses and to protect fundamental rights. And I think the AI Act will have an impact across all sectors and all sorts of technologies. And the rules we make today in the AI Act will impact, not only businesses, but our future society as a whole. And if we make bold choices today, we can be on the right side of history. So what I think is very important is that we make conscious choices about when, where, and how we use these technologies. And we need to protect people's rights as the first and foremost goal. And, this is something that's, I feel, still lacking a little bit in what is on the table now in the Council. So the extension of the prohibition of social scoring, as I said, I'm happy with it, but it's the only really bold move that the Council has made so far. And what we see is that the Council is really falling for, the narrative that any rules will hamper innovation, which is really, pushed by big tech-funded think tanks and large businesses. And I think with the narrowing of the scope and the exemption for research in the legislation, which we'll speak about later. So I think the Council has so far done this without making bold choices for human rights, other than extending the ban on social scoring. And this makes me a bit less optimistic, because I have the feeling that, we in the Parliament are more willing to do so. But also having to say that the Parliament still has to start. So we are behind right now.
Thank you very much. Yes, indeed, we are speculating now, and we are putting documents in the chat so that everyone can see. We also put the European Parliament study on the AI Act, which is the only document we can find on the from the European Parliament side. Okay, so now I would like to move to our EDPS, so to Dr. Wiewiórowski. As you know, the EDPS published an opinion about the AI Act proposal from the Commission, in which they mentioned some criticism, some a call for edits, including emotional recognition, biometric categorization, etc. So I wanted to ask, do you think the Council satisfactorily digested your opinion and criticism on the Commission proposal, or you think we are still far from addressing those points?
Thank you very much, first of all, for having me here and giving me this possibility to react somehow on what we get from the Council. I have to say that in most of mostly I'm positively surprised by the approach from the Council. We expected, looking at the examples of the previous discussions about similar solutions, that the approach of the Council will be much more cautious, I may say, creating any kind of strong regulations for the new technologies. Here we have the good and the bad things, or rather the positive and negative solutions that were proposed by the Council. They were already somehow commented. I would start from these good examples first. Well, definitely the social scoring is a very good example, despite the fact that we don't know exactly what the social scoring will mean. But at the same time, the Council shows that it is possible to create the general ban for something, and at the same time accept the fact that the specific law can make an exceptions from that. That's very well said also in the recital to the proposed by the Council, where a possible exemption may exist, because we can understand that even the credit scoring is a kind of the social scoring as well, in this sense, because it is assessing the social situation of the person. So that would be something which I'm quite happy of. Also, on the positive note, we would have to say that the European Artificial Intelligence Board, according to the Council, should have the capacity to propose the updates to the AI Act annexes. These are the things that we definitely like. But, well, at the same time, I have to say that the approach of the compromise to the uses of artificial intelligence for the biometric identifications in publicly accessible spaces is concerning us. It actually extends the broad set of exemptions that were already existing. And moreover, the changes which are introduced by the Council may increase the number of the allowed uses of the artificial intelligence for these purposes. The Council compromise has also ignored our proposal for the ban on the AI used to infer emotions, and that's something which we would be very keen on. Because the first examples of the use of that, especially in the labor law, in the labor situations, in the employment situations, are really thrilling. So I would say that these are the things that we definitely will try to discuss with the representatives of the Council in the nearest future. So let's say that's mostly the positive approach from the Council. Still the things to be discussed, and I strongly believe that taking into consideration the discussion that we already have in the Parliament, we will be able to go to some logic compromise.
Yeah, thank you. It was so we are honored to have given the EDFS the opportunity to have a first comment on this council first text. And I see that in the audience we have also representative of member states, including the presidency, etc. So in the Q&A, and please use the chat even now if you have questions. Now I would like to go to our Professor Mireille Hildebrandt. What do you think are the main strengths or weaknesses of this new text? You have a very big picture of the AI Act regulation, so we would love to hear from you.
Yes, and if I may, I'm going to start with a quote, which I find very important for the already for the Commission's proposal. It's a quote from a new book that just came out, an edited volume by Friederike Kalteuner under the name of Fake AI, and she interviews Princeton computer science professor Arvind Narayanan, who, I quote, says the following: "Much of what is sold commercially today as AI is what I call snake oil. We have no evidence that it works, and based on our scientific understanding of the relevant domains, we have strong reasons to believe that it couldn't possibly work. There has been genuinely remarkable scientific progress, but because of this, companies put all kinds of systems under the AI umbrella, including those you would have more accurately called regression 20 years ago or statistics, except that statistics ask rigorous questions about whether something is working and how we can quantify it. Because of the hype, people have skipped this step, and the public and policymakers have bought into it. For me, this is an extremely important point. And the beauty of the Commission proposal, the AI Act, is those Articles 7 to 17, with a whole set of stringent requirements about the quality, which would enable to root out all what is now called the crapware that is around, in the case something is qualified as high risk. This is, I think, the main and very important thing of the Act. And many people think that's only about safety. No, that is particularly the case for all the behavioral stuff that is built and that is a risk for fundamental rights and freedoms. If we would get those technologies tested, verified, validated, we could say they are pseudoscience, they don't do what they claim, and therefore no conformity assessment can be given, then we have solved the majority of the problems also on the side of fundamental rights. Now, I'm going to cherry pick because a lot has already been discussed. So I'm going to skip over the strong points of the proposal. Social scoring, I think everybody's very happy with that, though there's still a lot to be said about how it is articulated. And I want to move to two, I think, very problematic issues around the definition of AI. First of all, so the definition has been rewritten. First of all, it no longer speaks of software. I think a lot of people ridiculized the AI Act's formulation of systems in terms of software, and I think that was wrong. I think it was actually a good idea. It's now no longer speaking of software, but of system. I'm in principle fine with that, and maybe it reduces the amount of ridicule that comes from different sides. I have two problems with the current definition. First of all, it seems to be the intention of the Council to remove ADM systems from the scope of the Act. So that's automated decision-making systems, and I group under that also automatic decision-making that is used as a support system. The great thing about the Act, other than Article 22 of the GDPR, is that we are not only talking about decisions that have been taken fully automatically. The Act takes into account, for instance, in Article 14, under point whatever it was, I've got that there is something called automation bias. So if you put a human in the loop, as it's wonderfully called, this doesn't mean that you're not de facto in reality entirely relying on these systems. I think that in principle, these requirements about the quality of these systems are extremely important for ADM systems. So taking them out of the Act is a very bad idea. And there are lots of other questions. So this refers to Recital 6, where basically it is said that the Act should not be about classic software that is normally not considered to be AI. And there are so many issues with that. So what if, as is usually the case, there is an ADM system that is completely determined, is not machine learning system. It's what the Act would call a classic system, but it is built on the output of a machine learning system. How is that going to be qualified? And what if we have a machine learning system that somehow falls under one of the categories in Annex 3, so that is qualified as high risk, but in fact doesn't have the enormous amount of impact that an ADM system that falls within one of the contexts of Annex 3. Think of social benefits. This is usually done by ADM systems. These ADM systems may be based on the output of machine learning. It may not be the case, but the impact is the same. So my question is, why should the Council move away from the OECD definition that's much more impact-oriented? And also, of course, then a gap is going to appear between what is protected under Article 22 and 15 of the GDPR, so the automated decisions, and what the Act protects. There's going to be a gap. And once again, what is crucial here is that all these ADM systems that have a major impact on people's lives should go through the quality control of Article 7 to 17. That's absolutely key. We do not want people's benefits to be taken away. We do not want people not being recruited because the software does not do what it claims it does. And this is so often the case that we really need Article 7 to 17 on that. The second problem, Michael Veal drew my attention to it, is the fact that general purpose artificial intelligence is now out of scope in a very complex way. It is put out of scope of the Act. Basically, the bottom line is that this is going to leave big tech off the hook, while potentially making downstream providers that use general purpose AI liable for that use, whereas those that provide it are off the hook. In my opinion, that would turn the AI Act into a hoax. It would be totally ineffective. Big tech would outsource the legal risk to the downstream providers. We do not want that. It is also in contradiction with other parts of the legislation framework. The summing up of what constitutes general purpose AI looks to me like Borges' filing system. It says that AI systems that are able to perform generally applicable functions such as image peak recognition, audio video generation, pattern detection, that's about all. Question answering, translation, etc. So what about cloud services? I just saw this morning about the breakdown of Amazon Cloud this week. What if it's going to be off the hook because this seems to be a general purpose AI system? I think that's very problematic. And I even think when you look at the definition of the new definition of critical infrastructure in Article 44A or Recital 44A, an asset or system or part thereof which is necessary for the delivery of a service that is essential for the maintenance of vital societal functions or economic activities, blah, blah, blah. Think of the smart grid. Think of the role of cloud computing, but also of pattern detection, question answering, translation, video, audio for critical infrastructure. So I think it should fall there and not be excluded from the Act. I have many more remarks, etc., but I think I'll leave it to this.
Sorry, I was muted. Thank you so much, Mireille. We appreciated them so much, these points, because these points were really deep. Before Brando Benifei goes away, we had a very final questions for him, because we know he needs to go. If he wants to reply to what the other speakers said, I would in particular highlight the point on the blacklist and high risk that also Wojciech was mentioning, about the fact that they didn't take into account so much the EDPS position on emotion or biometric categorization, or also the mentioning on research, exemption, and AI definition. Something I know you have to go, so.
Yeah, no, I will just say this, because also I cannot say too much on such specific points before we actually have a discussion with the other colleagues. But I can say that coming, in my view, from the existing positions that the Parliament has already taken, both the recent resolution on the biometric recognition, and also the ethical aspects of AI, that was the Iban Garcia del Blanco report, that is, and I can also add, based on the work that we are doing now on the AIDA report, the Special Committee on Artificial Intelligence, that will produce soon a report, I would say that we will push from the Parliament side to look more into these topics, and not just play the game of just ignoring that sometimes the Council could try to just not engage with complicated discussions and decisions, but we cannot just leave. I also want to underline what Vincenzo Tiani was putting in his initial presentation, the issue regarding the individual remedies. We still think this needs to be addressed in a much stronger way. So I think that based also on my discussions with council members that I had in these weeks, we are still not in a very consolidated phase. So we are going to see probably more changes, also based on the changes at the political level in the EU, and the Parliament will try to be as much as possible united, because I think that on 3-4 points that were also mentioned today, if the Parliament is united, we can shift the overall direction, not only from Council position, but also from the original stance of the Commission proposal itself. So thank you very much, and see you soon. And thanks to the other speakers.
Thank you so much for finding the time, and it's very important to have also you here. Thank you. Now I would move to your colleague again for the second round. To Ms. Kim von Sparrentak, I wanted to ask also comments on what the other two speakers said. In particular, something maybe we are interested in addition to the AI definition, which is a very general and key topic. Maybe it's also about a blacklist and a high-risk list. You dealt with vulnerable people in the past of your political activity. So also there's something we didn't have time to address so much today, but also the definition of vulnerability has changed a bit because now they include also social and economic condition. When we asked at the Brussels Privacy Symposium 1 month ago to the European Commission AI director why they just considered age and disability, they said because they are easily recognizable. Age is on an ID card and disability is on a medical certificate. Now the council proposes something more. So this is maybe food for thought. And in general, what do you think of this blacklist changes?
Yeah, thank you very much. Well, I think, the safeguard of prior judicial authorization for biometric surveillance is a first step in showing the member states take this issue seriously. But I think it's not enough. So I think, for example, the current so-called ban on facial recognition for public use has so many requirements and such broad exceptions that it still allows for biometric surveillance cameras to be installed on any corner of the streets, both by law enforcement and private actors. I think, because facial surveillance happens without us knowing, as the Council has precisely clarified in their text, you can never control whether it's actually been used in accordance with safeguards at all until it's too late. And then, if you are specifically worried about whether you can protect children against this, well, if it's in public space, you can't really control that. Yes, you can check whether they have an ID, but then what? Are you going to block them from walking in the streets with biometric surveillance cameras? Like, how does this work in practice? And next to that, I think, one of the things that I find still very frustrating in this whole discussion is how a camera should stop terrorism or criminality. I think this is something that we will discuss way more often. But also I would like, to react a bit on the scope along these lines, because as I said, I'm happy the ban on social scoring has been extended. But if we truly want to protect fundamental rights and legal clarity, we need a broad scope. In the Netherlands, there was a child care benefit scandal, and thousands of parents had to pay back all of their child care benefits ever received because the system had flagged them as possibly fraudulent. And one of the factors to flag people for fraud was whether they were Dutch or not. And people were plummeted into thousands and thousands of euros of debt from one day to another. And this has truly ruined people's lives, like their kids were taken away from them. And this was not sci-fi technology. This was just a simple algorithm. And not only the most complex systems need rules. And I think what is crucial is that we need basic rules on how and where we deploy certain automation technology, specifically also to protect vulnerable people, because we know they are the ones that are mostly targeted by these kind of systems, unfortunately, in our society. And I think the more that we narrow down the scope of the AI Act, the more we leave legal voice. I think also, as Mireille already said, removing ADMs from the scope would be disastrous. And keeping the scope broad also gives legal clarity instead of leaving lots of room for interpretation on whether the system, how the system is programmed.
Thank you very much. I think you gave us very concrete examples on which we should reflect, because sometimes we tend to be very much like abstract, but the examples are great. And going back to Wojciech Wiewiórowski, my follow-up question for him was, yeah, in general, to comment on these points. In particular, I think Mireille raised an interesting point on the overlap between the GDPR and the AI Act, and now might change with this new proposal, because the Article 22 and 13, 14, 15 about ADM is quite different from the new definition. This is one first point that maybe the EDPS would like to comment. And the second point is again on the blacklist, because as we were saying, yeah, emotional recognition was not recognized, but maybe, as you also were saying, manipulation has been extended through this new vulnerability concept, and also social scoring to the private context, as you were saying, might be a way to cover also the commercial aspect of it. So I know it's a very big and complex questions, but yeah, the floor is yours.
Thank you very much. Unfortunately, the first part of your question has escaped from my mind, because I didn't have the contact with you, and I couldn't hear anything when you asked the first part of the question. But so if you can just repeat this.
I was just taking from Mireille Hildebrandt point of the overlap between Article 22, the GDPR, yes, and the new shorter definition of AI in the AI Act, if this is something we should worry about.
I'm not sure if there is a good answer to the question how the definition should look like at all, because in the first proposal that was given by the Commission, I had a feeling that actually most of the expert systems, which are rule-based, would qualify for the Commission proposal of the definition, and even the system which checks the speed on the motorway and then propose our fines would be called artificial intelligence, though there's absolutely no artificial intelligence in it. The Council tries to fight with it, but I think it goes definitely much too far. And that's also the thing which we see in this in the changes the Council did as far as the facial recognition is concerned, because on one hand they try to change the scope by moving from remote biometric recognition to the real-time recognition, which are completely two different dimensions. Yeah, they are probably both to be discussed, but this is not the change of in one dimension at the same time. And on the other hand, what is very good in the work of the Council is that they didn't lose the fact that the decision should be done about the remote recognition in the publicly accessible areas, not the areas which are owned by the public bodies. The ownership of the land does not matter at all. What matters is if you have the possibility to be there without being recognized and without being identified in the normal life. So it should the same apply to the land, to the territory which is owned by the public authorities and those that are in the hands of the private persons. Definitely the automatic decision-making process is not the only one that has to be taken into consideration when we think about the AI. And that's very good, very well visible when you try to think about the research exemption and to try to imagine what does it mean, research exemption, and how far we can go with deciding that the entity which is at the same time dealing with the academic work or scientific work, and which is helping the law enforcement authorities, for example, or the other authorities of this kind, can use these techniques. So all in all, as I said, the step in the good direction, with a lot of things to still discuss about. But on the other hand, let's understand this is not the easy part of the story. We don't know actually even which parts of the market and which parts of the activity we want to regulate. We are using the artificial intelligence, which is the marketing notion, and we try to give it the legal meaning.
Yeah, I think the research exemption point was key, and you just preceded my question. So I wanted to ask Mireille more about this. What do you think about the research exemption in the new council proposal? You already mentioned it in general. I mean, I think we all agree that research can be very much problematic in legal and ethical terms. So what do you think about this? You're muted.
When do we learn to put on our mic in time? I agree with Wojciech. So there, especially when academics are going to build stuff for or in collaboration with public administration, criminal justice, that means it remains entirely outside of the commercial space. Then that seems to be condoned. And I admit, or I don't admit, I think that's a very important point, and that's not addressed. What I do like is that outside of that particular example, for me, the research exception is very clear. So first of all, it says that AI systems research and developed for the sole purpose of research and developments are outside the scope of the Act. And then it says product-oriented research by providers that results in placing on the market or putting into service under own name or brand is within scope. Now, that basically means that a company that has an R&D department, they're doing open innovation, collaborating with academics, but at some point they're going to put the results of that on the market. No research exception. And I think that's right. I think a lot of my colleagues who are developing AI in academia will not be happy with that. And they've already voiced that very loudly, saying, but we are collaborating with the industry, and then they won't collaborate and Europe will come to run behind. And I can understand all that, but I think if we want a research exemption, which means that, so let's be very concrete what that means. That means you're doing research, you're developing a system, you're making it available. Yeah, you're putting it on GitHub. Others can do things with it. It means that you do not have to anticipate that that stuff can be used for other purposes than what you intended. You don't have to look into that. Everybody else, that's core to the accountability of the provider, should not only make sure that it works as claimed for intended purpose. That's one thing, that's very important. But they also have to assess the risk to health, safety, and fundamental rights if somebody uses it for another purpose. If you tell this to companies, they will say, are you crazy? I built this, I've told you what to use it for. If you then want to use it for something else, that's not my problem. That's how product liability works at this moment. I think the Act is very brave, and it's very important to say, no, if you share this, put it on the market, put it into service, and you have to foresee what is reasonably likely foreseeable, other use, and the impact of that. Now, by giving this research exception, the researchers do not have to anticipate that. So I think they get a lot of leeway. But I also think that the point that Wojciech makes is important. Also note that the definition of provider is tightened. It was with a view to putting on the market, putting into service, and now it is the entity that puts on the market or puts into service. So only if you actually put it into service, this whole network of obligations comes on, and that means it's tightened in the sense that the liability will be less, right? Because it only starts if you actually put something on the market.
Yes, thank you so much. I think this exchange is great. I know that Kim should leave soon, maybe, so I wanted to ask her one last rapid question before we go to the Q&A. There's no time to include her in the Q&A, I'm sorry. So one point was about institutional developments, because the initial Commission proposal gives the possibility to amend the high risk list just to the European Commission every 12 months. Now the Council say 24 months, but why not, for example, including also the EDPS or DDPB or national authority? I don't know. Why just the Commission should update the high risk list, and why just the high risk list, not the blacklist? So I don't know if you have opinions on this European Commission power.
Thank you very much. I mean, I think in general, it's better to have, of course, a European authority, whether it's a Commission or another authority who does it on a European level. I think that is the first thing that is very important, that it doesn't become very dispersed and every member state has to do this for themselves. But what I think is very crucial when it comes to this, and also when we're talking about digital affairs in general, we're now writing very important digital legislation, and we know that we can be, really at the forefront of what kind of standards we set in the world, but only if we make sure that enforcement and these kind of checks are well cared for. And we know from the GDPR that the system we have in place right now isn't working. So I think one of the most important things is that it happens on a European level, especially when we're talking about these new developments. And I think it would make the most sense that if we have a separate authority on digital affairs and also development, so that they really also have an overview of what is happening, and in that way we have experts involved in deciding. Because in the end, if the Commission has to keep track of everything that is happening in the AI world, this might be a bit difficult for them to manage. And I think that would be the best way forward. And indeed, we don't know yet what kind of things will emerge. So only keeping it at the high risk might not be the best way forward. Perhaps someone comes up with something that no one has thought of before, then it's quite important that we can ban it as well if it's something very problematic.
Thank you so much. So yeah, we all agree that a bottom-up approach would be better than a top-down for this. Yes, I think this is a great point. So if you have to leave, thank you again for being with us. So now we open the Q&A. So for the Q&A, we have also a small surprise, because we are having an additional panelist for the Q&A. We had some program problems, so we could include. We have two different sets of panelists. So we have Kathleen Müller. She's president and co-founder of Ally, an independent organization that promotes responsible AI. She's former member of the EU high-level expert group on AI rapporteur at the European Economic and Social Committee, and expert of the Council of Europe and OECD. So you see how many different institutions we have at this table today. Maybe we already have a question, but if while other people type their question, I will collect 3 of them, and I would like to give Kathleen the possibility just to rapidly comment a few minutes about what she heard so far.
Thank you very much. Thank you very much for having me, and I'm happy to step in at this late moment in the event. No problem there. I've heard so many interesting remarks already from the other speakers, and very in depth already. So a couple of things, we can talk about this forever, but a couple of things that I want to say. First of all, about the biometric recognition. Another approach to this could be to turn the entire thing around and say we ban automatic identification and categorization, and we allow it only in very exceptional cases, such as the ones that are now in the exceptions for law enforcement. That is another way to approach things. You could maybe come to a compromise with this rather than moving into all these kinds of discussions about what should be included and excluded. Another thing that I would that I fully agree with is that the extension of social scoring is really good, but it was already said that we should really determine what do we exactly mean by social scoring. Where do we draw the line between social scoring and between reasonable and acceptable assessment practices? And you can draw that line more clearly than that the AI Act is doing at this point. I fully agree with Mireille, where she says the maybe even more important element of this act are the requirements for high-risk AI. And the question that we also need to ask there is, do these requirements, the way they are described right now, do they actually prevent the harm to health, safety, and fundamental rights as they are supposed to do? So the next step would really be to look into those requirements and pull them apart and see if in any case and in every case these requirements do what they are supposed to do. Another thing is that we should also be aware of what is now on the high-risk list is quite invasive, and it sounds logical that those things should be on the high-risk list. AI at work, education, access to education, social services, etc. But it also risks normalizing and mainstreaming and even legitimizing all types of AI, the ones that Mireille also talked about, that are still heavily scrutinized. So we should not think, well, once we talk about, we settle the prohibitions, we're done. The major work, the major part of the work is going to come with the high-risk list and with the requirements. On the general purpose AI, there was a very good point. First of all, what is general purpose AI? What do we mean by that? Is that the foundational models that Stanford talks about, like BERT and GDPR or other things? So, and if you exclude those, aren't you excluding everything? Then the last point I want to make about the exception for research. I think we should be really, we should think that through really well, because research also has an obligation to present their research, to be open about what they research. And with this technology, it's not something that you develop in the lab and nobody ever gets to see it. Anyone can copy it. Anyone can work with the results of research in AI. So this exemption is really, it would mean maybe an exemption towards everybody, because how are you going to check that, for example, research in artificial general intelligence, artificial consciousness, things that might not even arrive or might be too far-fetched, but the research is still happening. And how do you keep track of people taking that research, building things with that, and just starting to use it? So those are my first remarks. But
thank you so much.
I'll leave it to that.
So much. I think we have already several questions. So I will read 3 questions, but first we have 2 people that raised their hand, Jurai and Risto. But please keep your question to 30 seconds because we have many things. So Jurai, if you can use your microphone. I don't know if you're allowed to. I think because Teams is having. While we fix this, I read the question I was receiving in the chat, so to our panelists. The first thing is that, so I read the question by Jens Henrik Jepsen, that basically health and safety framework is at issue for standards and specification. The question is, should the Artificial Intelligence Act have a process-based fundamental rights impact assessment for this application? So it's about the risk assessment already in the AI Act, if it should be extended to fundamental rights. I'll collect other 2 questions in the chat. The following one is the benefits of AI. Of course, we are a privacy arena here, so we are more concerned with the risks. but what will be how will the regulation support the growth of AI, if you think it will also help or it will be just an obstacle? And then we go with the third one, which is by Oscar Joseph Getrain. Do the panelists think that the proposed AI Act fits with a larger vision on the regulation of technology of the EU? Because, for example, we have different proposals, the SA, the MA, etc. Also, the JIG work was commented yesterday by Vincenzo on our website. How is the relationship between all of them working in your view? Are they different stars in the same sky? Or so I would go. Who want to go first among our panelists with these questions, and then we'll give the floor to Mireille and Risto for the voice questions. Maybe Wojciech?
If I can make one statement somehow, that's obvious that we are absolutely aware of the goodwill of those who are developing the AI solutions, and the proper use of that and the good results of the work of the AI systems and AI technologies in the future are absolutely normal for us. So the fact that we are discussing about the limitations, the fact that we are discussing about the risk that is connected with it is simply something that we have as the either legislators or those who are advising the legislators take into consideration. But it does not change the fact, which was very well shown in this pyramid that was presented first in the German report on the AI, later on in the Commission documents, shows that 95% of the uses of the AI are absolutely good and supported. We are talking about the tip of the iceberg, which is always visible for the regulators and for those who are dealing with the problems.
Other speakers want to react on these first three questions? Mireille?
Yeah, so this is very interesting because I just quoted Narayan saying the opposite. And I think it is very important to get this right. I think we should stop putting in all documents, policy documents, first that we are going to pray to the God of innovation, and then after that say, well, there are some drawbacks that we're going to address now. The point is, what I understand is that we in Europe, we want innovation if that solves a problem that we actually have, not a problem that fits with the technology that we happen to develop. And then we want even more than that. We want good innovation. And the question is, what is good? We're going to disagree about that, but the least should be that it's reliable in the sense that if somebody sells it as doing this, ABCD, that it actually does ABCD. And it cannot be too much to ask that somebody actually shows that. And much is going to depend in that sense, I think, on the private law liability framework that's going to come somewhere next year. The minute you decide, okay, if you're going to make profit, if you want to put this on the market and you're going to make profit, and you want to take a risk, not with your own money, that's your problem, but with other people's lives, livelihoods, earning capacity, access to housing, education, etc., then there are certain requirements. And if it turns out after the fact, so the whole act is based on the fact that you do a conformity assessment, and in the case of safety, that is externally audited. In the case of human rights, because nobody knows how to do that, you can do it yourself. That's problematic, of course. But after that, if it turns out that you have actually been violating fundamental rights or caused safety or health problems, you're going to pay. And I think it's the most normal thing in the world, and we shouldn't always be apologetic. Yes, sorry, you're taking a lot of risks with other people, but we should praise you because we like people to take risks. There is a difference with whose assets you take risk. Your own, no problem. Somebody else's, it is a problem, and we're going to call you to account. And so, yes, benefits, yes, innovation, But we want only good innovation. And I think it will last longer, and we won't have all these externalized costs that if China and the United States want to run into the wall, then we shouldn't stand in their way. We can warn them and say, don't do it. But we should just make our own path. Besides that, I think the United States are moving very fast here. If you look at the director of the FTC and a lot of other things that are happening now, I think they might take more bold steps than we do, actually.
Kathleen, do you want to rapidly address some of these points?
Yes. Yes, absolutely. I cannot agree more with what was just said, and I think we should also always remember that regulation can also be, or often is, a stepping stone for innovation, and it creates a level playing field. It creates a field where you know that your competitor is allowed to do exactly the same as you are allowed to do, and if you look at the requirements in the for the high risk AI now in the AI Act, these requirements alone lift the quality of AI to higher levels, promote innovation, push people towards better AI. So we shouldn't be afraid of it hampering innovation. Another thing I would like to say, and people need to remember that AI does not operate in a lawless world. It is not an unregulated technology. The effects of it, the harm to fundamental rights have been around forever. Liability laws have been around forever. They might not be perfect and perfectly fit to this typical situation, but that doesn't mean that you can just run around with your AI system and do everything with it. I mean, I just want to keep making that point, and we should be aware of that. And the interplay between the DSA, the DMA, the Platform Workers Directive with algorithmic management and existing legislation, we should be very aware of that interplay as well. And people should know how that works. It's difficult, but the technology is difficult.
Thank you. Vincenzo, did you want to add something on this interplay?
Yeah, actually, yes. I think that's what the EU is trying to accomplish, is to ensure more transparency. So we use technology every day. We have, smartphone, computers, and so on. The problem is that we don't know how they work. So until they are just, a piece of furniture, it's not a big deal. But once they start to interact really change our lives, because, as you said, basic on my economic situation, I couldn't afford a mortgage, or to go to the bank and so on, to buy a house or to be hired by a company. Then we need to know the rules. There's no way. GDPR tries to do that, introduce really transparency, fairness, accountability, and DSA, DMA are doing this, and AI Act will do as well. So.
Thank you very much. Our time would be over, but we'll have many questions. If the speakers can be 2 minutes more, I would give the floor to Risto. If you have to go, don't worry. Risto, can you speak? Or you have problem? Because, yes? Okay, yeah, please, very, very rapidly. I think you are muted. We cannot hear you. Maybe there's a problem in the things. But I have a short question for Wojciech and Mireille. If you can give like 1 second, 1 minute, 30-second question, sorry, answer. Non-discrimination. There was a question about non-discrimination. Do you think the AI Act will help to address the problem that are still on the table, even with non-discrimination law?
To be frank, I have doubts if you can technically approach this subject. And I don't think that the Artificial Intelligence Act has been created in order to create some new approach to human rights or new approach to the human being. That's still the same human being. That's still the same. These are still the same rights. So some of the solutions that are proposed here may probably build a good environment for that, but I wouldn't expect any clause that the norm that comes out of this act that would especially help with the discrimination problems.
Mireille, do you agree?
I think a bias audit as a sort of a default, which seems to be in there, is good as long as we do not expect that it is going to solve the problem. So it's not we're going to fix the bias, but you have to do a bias audit and show that you've thought about it and how, and it must be shown in a transparent way. So I think that helps. And there is also this, so the GDPR prohibits processing on the basis of special category data, which is very closely related to non-discrimination law. If you want to do a bias audit, you have to process that data, and the Act gives an exception compared to Article 9 of the GDPR. Sorry to talk so technical, but I think this is, I'm not entirely sure, but I think at some point we may have to decide to accept that exception, but there are a lot of risks there. So I think this should get more attention. I think it's Article 10.4 or something like that. And so it's not a legal basis, of course, for the processing of that data. You'll need a legal basis for that. But then the prohibition is relaxed for the sole purpose of doing the bias check. And without that data, you cannot do the bias check. And then, for instance, recidivism scoring software developers, sorry for the long word, will say, oh, no, we didn't use those features at all. If you can prove that we're biased, go ahead. No, I can't prove that because I'm not allowed to use those data. So these are real issues that we have to confront because there are also risks in allowing that.
Thank you so much. I think we are going to close, but I wanted to give to Katalin the final opportunity to comment on this point or on other questions that she saw in the chat. And then we really say bye-bye to everyone.
Yeah, I just want to add to the last point because it's one of the larger discussions, the biased outcomes of artificial intelligence systems, and I think that the AI Act tends to overlook the fact that biased outcomes are not just the result of low quality data. AI is a certain type of model. It works in a social technical system where biases can creep in from many sides. They can creep in via the data, of course. They can creep in via modeling, of course. But you also have, for example, confirmation bias of people that then receive an automated decision on their desk to review. So we should look at the larger social technical system around artificial intelligence if we really want to solve the problems that AI can bring, and not just at the technology itself. Fixing the technology is not going to fix the entire issue.
I would love to give the floor to everyone else and there are so many questions. This is great. I am amazed, but we are 5 minutes late, and also I know that our guests need to go. We will organize a new event end of January, so you are all invited, and we will update soon. Thank you so much to everyone, to Mireille, Katalin, Wojciech, and Vincenzo, Mohammed, Michael, the hub in general, and you all. Thank you, and see you soon. Bye-bye.